She sued a school district for $340K. The footage changed everything. She sued a school district for $340,000. The surveillance footage was supposed to destroy her case. Instead, it saved it. The wedding vendor had built her business the old-fashioned way, one referral at a time, over 11 years. She operated a boutique floral design studio out of a converted garage in a mid-sized suburb, and by most accounts, she was beloved. Brides drove 2 hours to meet with her. Her waiting list stretched 6 months. Then, on a Tuesday in March, her phone stopped ringing entirely. It took her 3 weeks to understand why. The school district in question was one of the largest in the county, nearly 14,000 students, a bureaucracy of roughly 800 employees, and a vendor database that stored the personal and financial information of every contractor who had ever done business with the district. The floral studio had decorated the district's annual gala for 4 consecutive years. To participate, vendors were required to submit tax identification numbers, banking details, and personal contact information through the district's online portal. In January of the same year, the district's IT department flagged a potential data vulnerability in that portal. According to internal communications later entered into evidence, the department sent 2 emails to district administration requesting an emergency patch. Both emails went unanswered for 6 weeks. By February, the vendor's information, along with that of 23 other contractors, had been posted to a public forum online. Her home address, her business banking routing number, her personal cell phone number, and one additional piece of information the vendor had never shared with any client: a personal bankruptcy filing from 8 years prior, buried in the breach data through a credit record linked to her tax ID. That bankruptcy, once public, spread fast. A local wedding planning Facebook group shared a screenshot. Someone left a review on her business page calling her financially unreliable. 4 brides canceled deposits within 10 days. Her busiest season became her worst. She filed suit against the school district for $340,000, covering lost contracts, reputational damages, and the cost of credit monitoring and legal fees. Her attorney argued the district had been negligent. They knew about the vulnerability. They did nothing. And their inaction cost her nearly everything she had spent a decade building. The district's defense was measured and, frankly, reasonable. Their attorney acknowledged the breach, but challenged the causation. How could the plaintiff prove the cancellations were tied to the leaked bankruptcy and not to ordinary market fluctuation? Brides cancel all the time, they argued. The floral industry is volatile. And critically, the bankruptcy was public record. It had always been findable by anyone who looked hard enough. The district hadn't created the information. They had simply failed to protect a door that, their attorney suggested, wasn't as locked as the plaintiff believed. It was a strong argument. The judge appeared to be listening carefully. Then came the surveillance footage. During discovery, the plaintiff's attorney had requested security footage from the district's administrative building, specifically from the IT department corridor, for the 6-week window between the first warning email and the data breach. The district initially claimed the footage had been routinely overwritten. Standard practice, they said, 30-day retention cycle, but the plaintiff's attorney had done something methodical. She had cross-referenced the overwrite claim against the district's own security contract, which stipulated a 90-day retention minimum for all administrative areas. The footage hadn't been overwritten, it had been deleted, and the deletion had occurred 4 days after the plaintiff filed her initial complaint. The judge did not need to hear much more after that. What the recovered metadata showed, pulled from a backup server the district's IT vendor still maintained, was that a senior administrator had accessed the security system remotely on a Sunday evening and manually purged 14 weeks of footage. The same administrator who had received both unanswered emails about the data vulnerability. The district's negligence argument collapsed into something worse than negligence. It became concealment. The judge ruled in the plaintiff's favor. The district was ordered to pay $287,500, less than the original ask, with the court declining to award punitive damages, but including full compensation for documented lost revenue, legal costs, and a mandated third-party audit of the district's data security infrastructure at the district's expense. The administrator who deleted the footage was placed on administrative leave pending a separate investigation. The floral studio did not close, but the vendor told a local reporter she wasn't sure she'd ever feel fully comfortable doing business with a public institution again. The 4 brides who had canceled never reached out. The Facebook posts stayed up. As for the administrator, the investigation into the deletion was ongoing at the time this case concluded. Whether it would result in criminal charges remained uncertain. Here's the question the case leaves behind. If the footage had never been recovered, if the deletion had worked, would any of this have come to light? And if the answer is no, how many stories exactly like this one simply never make it to a courtroom at all?